Torture has been around throughout history, but does it have a place in national security? Or should we draw the line at good cop and bad cop? We'll find out as we take an in-depth look at the United States interrogation practices, past and present, right now on Perceptions the Law.
Hi, I'm Jeffrey Addicott, and today we're going to talk about the issue of interrogation and torture. This is another hot-button issue that has been a subject of much debate over the years. Have we tortured people? We've all heard the allegation that the United States engages in torture. Waterboarding is torture. We torture people in Guantanamo Bay. It's simply a matter of looking at the facts. First of all, no one has ever been waterboarded at Guantanamo Bay. Never happened. After the invasion, or after the attack on 9/11 and our response with the campaign against the Taliban and Al-Qaeda in Afghanistan, the administration took a number of detainees, as we've seen. Some of the detainees, the high-value detainees, the top detainees, were detained by the CIA in off-site locations. The rest of them were put in Guantanamo Bay or Bagram Air Force Base. The ones in Bagram and the ones in Guantanamo Bay, the authority to deal with them was given to the Department of Defense. The Department of Defense had three categories of interrogation techniques that were authorized. Category 2 and Category 3 were only in existence for less than a month. The Category 1 techniques basically are extremely benign techniques dealing with standard operating procedures that the FBI uses every day. You know, you can lie to the individual, you can try to establish rapport, very minimal type of activities. No waterboarding, no physical abuse, none of that occurred at Guantanamo Bay because it wasn't authorized. Now, the CIA that detained individuals at off-site locations, they went to the Department of Justice and they said, look, we want to use enhanced interrogation techniques on these high-value detainees. One of them was Khalid Sheikh Mohammed, because we believe that they have information that we can use to stop future terror attacks. But none of them wanted to go to jail for torturing. The Torture Convention at that time was the primary legal authority dealing with interrogation. Now remember, we can interrogate detainees because they're unlawful enemy combatants. If you're an unlawful enemy combatant, we don't have to Mirandize you, and you do not have the right to remain silent because you're not a prisoner of war. So we have the authority to interrogate you as long as we don't violate existing laws. And of course, the foundation for all of this is the Torture Convention. The Torture Convention, which we're a party to, says that you may not engage in severe physical or mental suffering. But of course, what does that mean? Who's going to define what severe physical and mental suffering is? Again, is it going to be MSNBC? Is it going to be a senator? Is it going to be a pointy-headed law professor like myself? No. It's going to have to come from a competent court. They're going to tell us what severe mental or physical suffering is. And that's the Anglo-Saxon legal tradition. We're going to have a court. We're going to have to look at the court law. And then we extrapolate from existing court law, look at the practices that we're using, and try to make that determination whether or not we engaged in a violation of the Torture Convention. So as I said, the CIA got permission from the Department of Justice to use certain techniques against these high-value detainees. There was about 20 of them. The most notorious technique is the waterboarding technique. And if you look at the facts, the Department of Justice looked at the training that we did in our own military. We've waterboarded thousands and thousands of our own military personnel over the year in training. These will include Air Force pilots, Special Operations Forces, and that's where the Department of Justice basically got the idea for the enhanced interrogation techniques. The worst, of course, being waterboarding, which most people would say that's the worst. The actual technique, you take the detainee, put them on a flat surface, elevate it slightly backwards, blindfold them, and pour water, drops of water down their mouth. The Department of Justice said the technique cannot last more basically than a minute, and you have to tell them what they're doing. You have to have a medical personnel standing by, and the average waterboarding episode lasted about 10 seconds. Is it unpleasant? Yes. Is it uncomfortable? Yes. The question is it torture? Because we've heard many allegations, even from President Obama, that waterboarding is torture. In my legal opinion, waterboarding is not torture. I testified before the Senate. I was called to testify about a year and a half ago about this very issue. My opinion, not severe enough. Where did I get that idea? I got it from existing case law. The leading case in this regard, and the case that was relied on by the Department of Justice when they made their determination, is called Ireland versus United Kingdom. In this case, it was decided by the European Court of Human Rights. The European Court of Human Rights. They had to decide whether the British techniques against the IRA detainees constituted torture, that is, severe pain and suffering. The British techniques are called the 5 techniques. And one of them, they made the detainees stand spread eagle on their toes against a wall, leaning forward, for 30 hours, up to 30 hours. Now that pain is excruciating in your calf. If you don't believe me, try to do that for about 5 minutes and see what happens. They also hooded the detainees for days at a time, deprived them of food and water for days at a time, loud excruciating noises 3 days at a time. The European Court of Human Rights, by a vote of 14-3, so this was not even close, said, that's not severe enough to be torture. It's ill treatment, which is a lower level, but it's not torture. So therefore I argue that if that's not torture, then what we did is certainly not torture. It's far lower on the scale of pain and suffering than particularly the wall standing activity. And I extrapolated. Now, this court case, Ireland versus United Kingdom, was decided before the Torture Convention was adopted, but it was cited with approval in subsequent European Court of Human Rights cases. Also, the Public Committee case out of Israel basically made the same determination of the Israeli techniques. They said the techniques were illegal, they were ill treatment, but they weren't torture. I did testify rather humorously to the Senate. I said that I know that the senators that were questioning me were violating the Torture Convention, because the Torture Convention says quite clearly, if you believe that one of our agents has committed torture, you must prosecute. We have prosecuted no one in the Bush administration for this enhanced interrogation technique. So I know that our current government is violating the Torture Convention because they've made the determination that waterboarding is torture. And you must prosecute. We haven't prosecuted. We will not prosecute. So we have never tortured anyone. It simply never occurred. Until our Supreme Court says that our waterboarding technique constitutes torture, we can extrapolate from existing case law, most of it international, that it's simply not torture. We've had some Supreme Court cases that deal with things that shock the conscience. We don't have time to go into that now, but perhaps we'll have this issue to the Supreme Court, because one of the issues obviously that's going to be raised at the military commissions by Khalid Sheikh Mohammed, and 3 people were only waterboarded by the CIA. They're going to say, we were tortured, therefore the evidence that's derived cannot be used against us. And they're right. The military commission rules say that evidence derived from torture cannot be used. And then the judge is going to have to make the determination whether our waterboarding technique was severe enough to constitute torture. I don't think it was, but if he makes that determination, it's going to eventually go to the Supreme Court, and they're going to decide once and for all whether our technique constituted torture. So the word torture rolls off the tongue really easily. It's been used as a political piñata, obviously, by individuals for political power and political posturing. But in my opinion, we've never tortured anybody. And oh, by the way, Abu Ghraib was not ordered by the government. It was individual soldiers in their individual capacity on the night shift in Abu Ghraib without supervision that committed these abuses. So torture must be authorized by the government. The government did not authorize those activities in Abu Ghraib. Now, have we had soldiers in their individual capacity, as we indicated, that have tortured, that have murdered, that have done things? Yes. And we've prosecuted many of them. We prosecute everyone that we have enough evidence to bring them to court. All the major players in Abu Ghraib were prosecuted and convicted. So, it's critical that we apply critical thinking skills when we hear the issue that we torture people. And unfortunately, this is a war not just about putting steel on target, killing enemy combatants. It's a propaganda war. And we are not winning the propaganda war. Sometimes we do it to ourselves because we have people that demonize our processes. And sometimes these stories obviously are picked up in the national and international press. And people read Abu Ghraib and they automatically extend that to the fact that, oh, well, the American military tortures everybody. No, that is not correct. To stay up to date on the latest news, be sure to like us on Facebook or follow us on Twitter.